Thank you, Mr. Sabawal. I must say that when I joined this profession years ago, nearly 30 years ago, I heard about WIPO only because I heard about you first, sir. I've been in this practice for 30 years now. My name is Hari Subramania. I have a background in medicine and law. I will try to gallop a little bit because I've been told that there's a little bit of time constraint. As any patent attorney would like to testify, 10 minutes or 20 minutes is hardly time to speak on any topic. Each one of us could go on for 3 days on any topic here. What I'm going to talk about here is a few things that have been happening in the Indian judicial system and the patent law system here in the recent times based on actual case laws. India has been making a lot of news for various reasons, and not necessarily all wrong reasons, but sometimes the reasons get misquoted or misrepresented in the newspaper headlines, and then it causes a panic amongst people and stakeholders all over the world. At the same time, it's also important to understand that India has got its own laws. It's got national sovereign laws with the socioeconomic conditions of the people in mind, and it's a big country for people to come and do business in. So rather than worry about the law and get panicked about the law that we follow, it might be a good idea to understand the law the way it is and then play according to the rules there, and it'll be a lot easier to do business. Indian law recognizes that patents are granted to encourage inventions. At the same time, Indian law also places considerable importance to public. And that's not new, really. And there's not been too much of a shift in the policy changes as far as India is concerned. But what has happened in recent time is that we have an Intellectual Property Appellate Board, and we are former technical member of Appellate Board with Dr. Chandrasekhar sitting over here, also former Controller General of Patents. We also have courts who have realized that Indian law always had teeth, and just that the judges have learned to bite. That's all. But we do have certain thorns in the side as far as Indian patent system is concerned. And these are the things that we need to deal with, not just the time of when we have a problem, but right at the time of filing patent application, mostly even at the time of writing patent applications. The problems that people talk about all over the world is the fact that we have a pre-grant opposition, we have post-grant opposition, we have invalidation proceedings. There's apparently, seemingly, there's a bit of uncertainty in infringement actions, and there has been issues recently with respect to divisionals and duty of disclosure. Public is afforded several opportunities to question the validity of a patent. This is because there is never a guarantee of validity of the patent. There's only a presumption of validity. And the validity can be controverted any time until the last day of the life of the patent, just that there are different forums where which you can challenge the validity of the patent. But it does not mean that, I'm sorry, I'm quickly rushing through slides because time constraints, but we have had several cases where there have been little controversies in the way the law was applied, but now and then there have been judicial interventions and the law has been set right. Yet, when the law is nascent, in many ways, while we have a 100-year-old patent system, but there are some issues related to infringement actions and also pharmaceutical product patents. The law is recent, and therefore there are bound to be some mistakes. What we need to do is make sure that we don't create bad precedents, because bad precedents have a nasty way of staying there for a long time and coming up and biting you when you least want it. We must remember that India granted its first pharmaceutical product patent only late 2006 because the patents became patentable only after post-2005. And there have been serious concerns with various stakeholders, particularly because of several cases that went to the court. I'll talk about a few of them very quickly. I'll quickly jump to some of the case laws that we have been faced with in the last few years. Let me just see what are the cases here. I had a list of cases here. Okay. Now, one of the cases that made a lot of noise in India was about the compulsory license that was granted on a buyer patent recently. It's nothing new. Indian law always had a provision for compulsory license. Indian law says that patents are not granted merely to block imports and, advance of technology, but you got to actually work the invention in India. And if you don't, and the patented product does not meet the demands of the public at a reasonable price, any person can challenge the monopoly and then apply for compulsory license. The fact that compulsory license were not granted in the previous years did not mean that the law didn't exist. We were asked to take a look at this compulsory license case by not only the people concerned, but also the government to see whether anything was actually could have been done better. And we analyzed this rather carefully. And I must say that it was a fit case for a grant of compulsory license. When you have a drug, an anti-cancer drug, and a company has got manufacturing facilities in India, and the drug is mostly imported into India at the cost of about $5,000 per patient, the Indian company offers to sell it for $160 per patient, it's very difficult to justify the difference in cost. When you talk about a reasonable price, does not mean that anybody who offers a lower price will be given a compulsory license. Reasonable price would mean reasonable in the context. And it is completely understood that a patented product would cost a little bit more, just the way original music or a DVD would cost more than a pirated version. But at the same time, when the application of a compulsory license was defended by buyer, they were not able to show such a huge disparity in price. It was argued that there was a huge research cost and a patenting cost. But the patenting cost, it's not a worldwide patenting cost, had absolutely no issue on the cost of the drug in India. And the research cost argument failed because there were documents on file which showed that a considerable amount of research was funded by the government. So therefore, there was no way buyer could justify such differential in price. At the same time, there have been other cases where there's application for compulsory license filed against Mr.Hari's patent, and that was refused by the patent office. Medical use. We cannot have a second medical use patent in India, and new use of a known substance is not patentable, method of treatments are not patentable. These are statutory prohibitions. Yet, there have been possibilities where you can get an effective patent by claiming the product as a formulation, as synergistic composition, methods of preparation of compositions, method of preparation of substances, and can get effective patent. There was a case very recently which we prosecuted before the patent office on a huge hearing. It's a question of administering two compounds, one after other, one an anti-osteoporosis drug and another anti-inflammatory drug, calcitonin and glucocorticoid. And the patent office initially rejected it on the ground that it's only a method of treatment, and there was absolutely no support for anything else in the specification as a composition. Yet we managed to convert the claims into a method for preparation of a composition by bringing two compounds in contact with each other at a particular locus, and after hearing, patent office allowed the application. So therefore, there are ways, and similarly another case, very recent application where claims were amended to a synergistic composition containing two compounds where the two components come into contact only in the human body, but the claims were drafted to show that the two compounds came into contact with a predetermined locus, and as a synergistic composition, the claim was allowed. We also had another case we'll talk about is Novartis. There have been a lot of news about the Novartis application, why Novartis case was refused. And I'd like to set certain things right over here. Novartis compound was, the compound in question was beta-crystalline form of imatinib mesylate, and the Indian Patent Office refused the application on the ground that the beta-crystalline form did not exhibit any new efficacy as required by the patents law. Section 3D of the patents law says that when you have a new form of a known substance, it has to exhibit significant increase in efficacy as compared to the original compound. And in this particular case, all that was able to show, the applicant was able to show, was that there was a 30% increase in bioavailability. The matter went right up to the Supreme Court, And until the end, Novartis was not able to establish that the 30% increase in bioavailability also increased in therapeutic efficacy. Now, the Supreme Court rejected the application with a rider that the application was being refused because the 30% increase is only bioavailability and it's only increase in property, and it did not result in increase in therapeutic efficacy. Now, this is the case, it could be right and wrong. It's like looking at half a glass of water. It's either half full or half empty, depending upon whether you're thirsty or not. Now, looking at this case, Supreme Court seems right. At the same time, when you're looking at two drugs and one drug works better than other drug, and much considerably better, and if it works better because it has 30% increase in bioavailability, why should you not get a patent on that? Section 3D does not talk about only pharmaceutical products. It talks about new form of a known substance, any substance. What if Gleevec wasn't an anti-cancer drug? What if Gleevec was a shoe polish? Then what would Supreme Court have said? Because how do you show then therapeutic efficacy? The word therapeutic efficacy is not mentioned in the Patent Act at all. It simply talks about efficacy. So had it been a shoe polish, you only translate the efficacy in terms of better shine, longer shine, lasting shine. Similarly, Gleevec works much better as anti-cancer drug. So therefore, we believe that probably the case could have been better handled, better judged, and better prosecuted. We don't know. But we believe that probably this is a new lesson that we all learned from this particular case. It also brings to us the kind of disclosure that you require the patent specification to advance cases like this. And with that, that will be addressed by Dr. Mohan Diwan. Thank you very much for this patient listening. Thank you.